Esteemed friends and colleagues, good afternoon. I must apologize for the small delay in the start of the roundtable discussion. I hope you made good use of this time to network. There are many interesting things happening also outside these walls in Palace Square. Let's hope that this discussion will be interesting and fruitful all the same. So why are we assembled here? We all know that asset turnover generally, whether personal or corporate, is accelerating gradually. The economy is becoming more dynamic, and the present conditions require that we operate in a more straightforward and less convoluted way, with fewer administrative barriers. I'm sure most of those who are present here will be aware that our country, the Russian Federation, attempting to become more competitive and offer a more favorable environment for investors, has launched a project of simplifying many administrative procedures. This process, called the National Entrepreneurial Initiative, has been running for a number of years, and some simplification is happening. The same things must be happening elsewhere in other countries, because all countries now compete for investors in a transparent economy. You can't have both a tight regulation and a lot of investors, because investors will simply move elsewhere. But there is the flip side of this process, which might seem so uncontroversial. When we talk about asset turnover acceleration in stable jurisdictions, then it's all fine. In a stable system, there'll be little crime and few risks. But we have to ask ourselves what is required here in this country. Not so long ago, Russia went through the difficult and stormy period of the 1990s. It was a time when a law meant very little, let's be honest. And sometimes assets, not just personal assets, not just personal but also corporate assets, could be simply taken away in a radar attack. So the risk of asset loss was very real, and in a sense the memory sticks. Businesses and private individuals today are prepared to pay extra for a better protected business title. And if it comes to private individuals who are maybe engaging in the one big deal of their life, selling an apartment, they might be prepared to pay extra to a notary to protect themselves in this situation. So what should happen to the asset turnover? Should it be more straightforward? Should it be further simplified? Or are we prepared to pay for protection against possible threats of protection racket? This is what we're here to discuss. To make this debate a bit more exciting, let's add to it this thing. There is something called the Doing Business ranking, And I don't know if you're aware of it. I was once surprised to find some countries which are often quoted as the best possible environments for doing business, France or Germany, appear on that list in the late 90s. And Russia is higher up on this list, somewhere in the middle of the first 100. Mr. Fomichov will correct me if I'm wrong. Which countries rank first? One is Kyrgyzstan, two is Georgia, and Belarus is somewhere in the first dozen. Many lawyers have to ask this question. How come that Germany, or France or Switzerland are so low on this list while some other countries are so high? Is that ranking okay then? Let me introduce some of the speakers. Some of them could not be here. Lord Peter Goldsmith couldn't be here with us. He was delayed. His air flight was delayed, so he couldn't be here. I have, however, a number of panelists here. Mr. Dmitry Timofeyev, Director of the Department of Corporate Governance in Ankor-Dros. I think your company had a different name, Renova Construction Group. Paolo Pasqualis, President of the National Notaries Council of Italy. Welcome, sir. Oleg Fomichov, Deputy Minister for Economic Development of Russia, somebody I know very well in my work, the person responsible for all the progressive things in the Ministry of Economic Development. I hope as a progressist he'll argue with us conservatives here. Ruslan Ibragimov, Vice President for Corporate Matters in Mobile Systems, joint stock company. The lawyer of our mobile telephones, shall we say. Alevtina Kamilkova, head of legal department for Russia and CIL of Alcatel. Okay, another mobile phone operating company. Alexander Masyagin, senior vice president of Commerzbank Eurasia, so that will be the banking lawyer. What order do you think we should adopt? Should we ask the lady to speak first, or maybe there is somebody who would like to be the first to take the floor? Well, so the devil's advocate in our midst. All right, I can start and then you can argue with me. Our ministry traditionally has been attempting to simplify the processes of doing business in this country. There is a lot of argumentation. It's not just about It's not just about the competition of jurisdictions, but it's that businesses have to bear such numerous costs. We tried to make calculations of transactional costs, and I mean just simply transactional costs, nothing to do with labor or production costs. So transactional costs come to 30 to 35% depending on the industry. It's the cost of regulation. This involves not so much registration or title change, but it's regulation connected with security, environment, sanitary norms, etc., etc. there seems to be a pendulum swinging. First, we try to simplify the conditions, and then the pendulum swings the other way, and we tighten up regulation that we had been loosening. In this situation, macroeconomic dynamic shows that economic growth is almost at zero, and investment is negative starting from last year. I'm one of the few economists in the middle of so many lawyers. As a Secretary of State, I am, in my job, responsible for regulating legislative processes, but I'm an economist first and foremost. So I can say that simplifying regulatory processes is a way for investors to cut transaction costs and make the climate more favorable for investors. This, however, involves risks. If registration is simplified, then we need to put in place measures to stop shell companies springing up. If we simplify some procedures, say for the ICI roadmap to simplify registration, then there are consequences there too. For instance, we lifted the rule for paying in half the establishment capital, but with the requirement that the full foundation capital is to be paid in within 4 years. And the second measure was lifting the restriction on notary certification if the person submits documentation personally. I thought it was quite straightforward when a notary can certify the person of the submitter. The submitter still had to produce some documentation to prove that he or she is themselves. This was really nothing but an extra cost, an extra procedure, and we try to eradicate such senseless procedures. If, however, a norm contributes to security, then we're more cautious. We consult with businesses to see if they see a use in a particular procedure. And I can say with confidence that I cannot recall a single procedure that were lifted and this somehow washed away some of the security. Actually, to replace the process of notarial certification of a person's identity, instead of that, we introduced the rule to have notarial certification of the proxy deed. I don't think this made registration much simpler through that, because typically you don't have the future owner personally showing up in the office of the tax authorities rather than sending a deputy. So for still for the few cases of proprietors showing up personally, we have simplified the procedures. So we try to seek out those procedures whose removal will not be detrimental to the protection of the investors. Anyway, I believe businesses are those who must decide whether or not they want some procedure removed without any loss to their protection. And we need to see how many of the businesses find a particular procedure useful. Uh, Probably for the 10% of the largest companies, this might have some value, this notarial certification. But 90% of smaller businesses would see no use in that. Why not simply make the procedure voluntary? That would be a simplification for many of the smaller players and lift some of the financial and temporal burdens on the businesses. If, however, a certain measure is needed for greater protection of entrepreneurs and investors' rights, it would be some means to protect some means to help businesses encourage greater safety. Something like measures to protect the freedom of agreement, the dispositive rights. As an economist, I find this word difficult to say. The participative deals that are contracting deals that fully depend upon one party only. This is a measure to protect businesses from opportunistic actions of the counterparties. As far as I know, such measures are treated by the legal and the judicial community with a lot of caution, and this prevents a number of high-risk deals from being concluded, which in other countries are quite popular, all sorts of operations with venture capital and innovations. So together with the Ministry of Finance, we have made it possible for the investment community to exercise such deals, despite opposition of some members of the legal community. This takes us beyond our civil code, but in situations of business uncertainty, businesses can use this procedure to protect their interests. This, I believe, is the way to go in the future. Protecting proprietors' business rights, giving them more instruments to choose from voluntarily, with more forms of agreements and more forms of agreement protection. And at the same time, we will continue removing unnecessary procedures. Thank you, Oleg. I might like to abuse my mediator's rights to respond to some of the questions you raised. The notarial certification that you called stupid, it really stems from a situation that might be familiar to many of those present here. If there is collusion between the protection racketeer and the tax official that registers the company, then the notary is the only link in the chain that can break up this collusive agreement. In its time, the Ministry of Economic Development was the vehicle for amendments that applied to transactions with stocks of shares in limited liability companies. You will know that this has reduced the number of lawsuits related to that. Another story. St. Petersburg is the city where 5% or more of all property deals involve certification by notary. And this leads to less litigation, fewer lawsuits here. I'd like now invite Mr. Paolo Pasqualis to take the floor so he can tell us about the Italian situation after Oleg Fomichov's response.
Just to comment on two previous issues, of course, we need to maintain, especially in those cases when the third party's interests affected, then of course that would be the compulsory. If not, then it would be just voluntary. If we are talking about the liquidation of this notary certificate, then I believe it's not just the a sort of agreement with the notary officials. We are not losing, we are not winning. Thank you.
Thank you very much, Mr. Chairman, Mr. Deputy Minister, for this invitation, for the opportunity of speaking to such a distinguished audience. First of all, thank you very much for this invitation, this splendid city that is able to teach history, culture, and art to the entire world. Thank you very much. And how many things to say, to comment, just the starting of this debate this afternoon, having been called as the representative of notaries. Where to start? We are talking today of control, certainty, legal certainty, security, and bureaucracy, maybe sometimes stupid controls, but we have to better understand all these systems. Because today, as well, aside of simplification, of less bureaucracy, we always, every day, we ask to get to have more legal certainty, security, safety in our lives. If you see, when you hear of an accident all over the world, you see that immediately afterwards an inquiry is open, someone is checking if everything was well done, if all the rules have been respected, and normally we find that the rules of the laws existed. They were extremely maybe clear or severe, but many times we don't know why they were not respected or fully fulfilled. So please try to be, how to say, to find the right equilibrium, the right proportion between the need of simplification, of less bureaucracy, let's call that, and the other main need of safety for everyone. And so I am tired to hear debates on less bureaucracy without saying nothing on the importance of controls, security, and so on. And on the other end, of course, not all the controls are justified, are strictly useful, and so on. So, and this occurs in everyday life, not only on legal matters, I see. So, my idea is that, first of all, we have to better understand or to better study and then understand the function, the nature and function of each control in every step, for instance, of the transfer of an immovable property, of the creation of a new enterprise, and so on. Because just, I noted here from your words, protection of the environment, I can add immediately money laundering, fiscal matters, family law matters, for instance, they are normally involved in the majority of real estate transactions. And so this is the real modern actual role of the notaries, at least of the what we are proud to call civil law notaries, to distinguish as from the public notary, which is a different thing. And so, of course, our origin, the origin of my profession, is certainly certification, the need of certification. But now, really, this is a very, very, very small part of our job, because the main activity is just to control the legal value, the regularity of the entire content of the transaction. I could do many examples. Our legislations are extremely detailed sometimes on such a matter. And I insist, from the legitimation of the person signing the deed, of course, but the matrimonial property regime, the existence of a building permit, if they had already paid taxes, if is a transaction in which a money laundering could be involved, and so on. The registration, check if the property is already registered, regularly registered or not. So it is also a support to the activity, to the state, to the public functions, and so on. And so, how dare say, I frequently say to my clients that normally they don't understand the real function of my intervention sometimes. Please try to better use the notary. Try to use the notary for all the possibilities that he gives you, and don't be shy in asking, don't be shy in insisting, or even in underlying the liability of the notary himself or herself, and try to learn how better use your professional, that in many countries, whose assistance in many countries is compulsory, imposed by the law. And on the other end, another thing that I don't miss to mention, I don't want to miss to mention here, when we talk of less bureaucracy, please do not rely on some data rankings that are publishing all over the world. They mention, I suppose it's understood by the majority of you. I mean, the main, the main source of this data normally is the World Bank's annual report called Doing Business. And it is mentioned every year, the end of October normally, it is published. And in Italy, for instance, all the media, the week after, they quote the fact that Italy maybe is 5 or maybe 50 places in rank after Rwanda sometimes, or so on. And they like to mention this ranking. But my suggestion could be only this one. Please, if you have never done it already, please check this source by yourself. I mean, put on the screen, I have asked if there were an internet connection, but unfortunately we can't use it now here inside. But just search the web, or put the address is www.doingbusiness.org, and check the different sources for the different countries. Read the information they give you. It is already been mentioned, it has already been mentioned that, for instance, in the registering property, I had here just the screenshot of the registering property. I mean the formalities required and the steps required to register real estate transactions in different countries. At the first place is Georgia, second New Zealand maybe, and third Belarus. Germany is 81, for instance. And so all the main countries are very far from the top. And if you read what or which are the data given about Georgia, you just see that apparently to register a property in Georgia, you just need to fill the form of the public registry. Nothing is said about the content of an agreement. I suppose that to sell and to buy a property, even in Georgia, it's necessary maybe to sign a document or to check if the property really belongs to the seller, or maybe to pay even a small tax or a stamp duty, or to sign something, or to ask something to your seller, and so on. No. Apparently, on this world-recognized, why world-recognized database, you just find that you have to register the purchase title with the district public registry, and the public registry says just fill this form, give us the documents of your identity and so on, and you will be registered as the new owner. This will take you just obviously one procedure, and don't know why, 2 days. Then for New Zealand, it's almost the same, Belarus and so on. So please consider if this could be realistic. I mean, no mention of agreement, of controls, of quality of the object, I mean of the property itself. This is always a case of a building, because in the example given by doing business is always a building took into consideration. And so for a building, for instance, there are many laws referring to the building permit. Of course, now in the European Union, the certification about the so-called energetical efficiency and many other things to check and to control. So, just to give you an example, but you will find hundreds of good examples inside if you only check the data exactly. And this database is normally considered a sort of benchmark for even for the politicians. We have had in Italy some laws presented to the parliament saying that with this reform we will gain seven places in the rank of doing business, which has no sense at all, because probably only correcting the data given we can gain 11 or 20 places. So this is my personal, maybe too strong critical, or maybe too personal critical to the doing business database, which is not reliable at all. So just to remind you 2 things. Please find a solution between the needs and the opportunities of more safety, security and controls, and less bureaucracy on the other end. My personal opinion is this, that the solution could be a better preparation of the persons involved. I mean, in Italy, for instance, I notice a how to say, lack of formation in our national bureaucracy. We have old offices, not adequate formation of the officers inside, and too many details, or the need of too many controls, scientific, technical, that the people working there are not able to do, really. They are not formed to perform such a sort of controls. So very good, less bureaucracy, but better bureaucrats, better prepared. On the other end, be more precise in what is really the goal of the new rules, of the new laws. Be more realistic on the real possibilities to perform, to get effectiveness in such a control. So we can't only write down a law saying that this control will be introduced if we do not have the means to do so, please. So I maybe obviously know the condition in my country and so on. And second, please do not rely on those databases. They are not realistic at all. And so it's almost a joke to be every year at the end of the year waiting this rank, how to know the rank in doing business that is of no importance at all, in my opinion. Thank you very much. And I'm obviously ready for the debate and maybe to be clearer in some details. Thank you very much, Mr. Deputy.
Спасибо, Павлу, большое за...
Thank you very much, Paul. Thank you very much for a very interesting intervention. In our country, just a question, real estate transactions are not subject to notary agreements. We have multifunctional centers to provide public and public services. Why don't you have these multifunctional services in your country? So we have multifunctional services to provide public and civil services at the expense of the state. So my question is, why don't you have the same centers in your country? We believe that it would be less expensive to function by the state to the operation of these multifunctional centers.
Probably because the notarial system works very well, and it's reliable, above all, with a direct personal liability. We have an insurance covering all the professionals, a collective national insurance, a guarantee fund, and I dare say, we have a sort of specialization that, for the moment, fully fulfills the requirement of our system. High professionality, high liability, very good formation. Until now, or well, until 5 or 6 years ago, good earnings as well, not so much nowadays. But the system works. You see, like in the Anglo-Saxon countries, how, when, why to change when your system works perfectly. And so we, for the moment, we do think that this is the reason of that. Even if, you know, the government frequently says or asks how to change the system, maybe how to get better results. For the moment, we resist and we are especially in condition to perform what is asked.
Спасибо большое. Да, вот у нас-то все.
Thank you very much. So we have the same system, and we have at the same time the multifunctional centers system, which is operating. So I am responsible for the operation of these multifunctional centers. These centers are called in foreign countries as one-stop shop. They exist in many countries. They do not contradict to the notarial system, and they do not contradict to the state providing its own services. So no contradiction and no oppositions from the side of the notaries. And sometimes it's more convenient for a citizen to get services or comprehensive services in one shop, one-stop shop, rather than to go to 40 or even more offices. So it would be more convenient for him to apply to one institution to get services. If he needs more services, he can apply to notary services. I'm not arguing, I'm just asking why you don't have the same system in Italy.
We are the one-stop shop in Italy. I mean, from our office, unfortunately, I can't get now an internet connection. Otherwise, I could say how from my internet site I can get the register, all the data on the registration of the property, the map of the property himself, the cadastral certificate, to sign the document, to send immediately to the registration of, to pay taxes through my bank account electronically. So we realize, and this is for the Italian state, for the Italian government, a sort of outsourcing, immediate outsourcing, delegate the notaries. We do everything. We are the one-stop shop. We collect taxes as well. We are liable also for paying taxes for the client. So I say, and I insist, the system works. Don't believe that our tradition is so far from efficiency. Don't believe that.
Спасибо, Павлу, спасибо, Олег. Да, мы просто, чтобы больше не продолжать.
Thank you, Pavel. Thank you, Oleg. Just to stop this discussion, otherwise we don't have enough time for the other speakers. I would like to ask our bankers, Alexander, who has money now? Maybe bankers. Other people are quite poor. Are you going to overpay? Are you ready to overpay to have the stability or stability? Are you going to invest in order to ensure more stability? I wouldn't like to limit our the discussion to yes or no in terms of notarial service. It's quite clear that yes, but despite what Oleg is saying, but bank investment into the stability or security, are you going to overpay to that?
Yes, certainly the answer is yes, positive. And we welcome all the changes all the amendments introduced in the civil code concerning the collateral. Starting from the 1st of July, we will have a voluntary opportunity, voluntary, I stress that, for the members of the public to apply to the notary and register the deals. This is not a requirement, not a requirement to the form of the deal. So it does not affect the essence of the deal. It's just the choice of the parties to use it or not. I can speak on behalf of my bank. I represent Commerzbank, a German investor, the second largest bank in Germany after Deutsche Bank. So we have made a conclusion that all movable property collaterals that we accept in Russia will be registered. But to continue with the subject that was taken up by previous speakers, the doing business ranking, for instance, and the mention that such advanced jurisdictions as Germany find themselves closer to the second 100 in the rankings, whereas Kyrgyzstan, Belarus, and Georgia are on top of the list. Quite honestly, speaking from my experience and that of my colleagues, those who work for foreign investors in the Russian Federation, let me say this. What the investor needs is not so much the simplicity of title registration. It is the certainty that they can exercise their rights. If, for instance, the need for collateral arises, I will speak about collateral because this is more to do with the banking activities. What is Germany famous for in this respect? Well, Germany is the land where for more than 100 years the property registry uses the public viability principle, something that we only started recently in Russia. Irrespective of any kind of defects that a deal might have, once a deal is registered, it is valid. I will share with you one real-life case that you will be interested to hear about, something that happened to us in the line of business. We financed a Russian borrower. It was a big loan, and as collateral we accepted both movable and immovable property. Specifically on real estate, the collateral was oil wells and land plots where these wells were situated. The deal was registered in 2002. In 2010, we agreed on selling our rights to a third party, and we signed that agreement. Certainly the mortgage was registered. So after we ceded our rights to a third party, this agreement was also registered, and so was the right of the new collateral holder. After a while, a lawsuit was initiated, one to declare the collateral agreement null and void, because there was one big legal defect, including a material one. And they remember that list. The nature and the valuation of the collateral. So the snag was that in the list of collateral there was a table which listed those wells: well 1, well 2, well 3, well 4 and 5, and this table also gave the registered valuated price of the wells, and also the lease value of the land. Well, you know how it is with complicated deals. The valuation of the wells was easy to do. The balance sheet valuation was accepted and nobody questioned that. But the value of the lease rights of land was put down as zero because it looked so irrelevant. In fact, instead of the zero, the table contained a dash, and the complaint was the plot of land, ostensibly, was not valued at all. And this, the claimant said, makes the collateral agreement null and void. And they also wanted to launch a complaint against the cessation of rights. Now, my employer was flabbergasted. He said, "Wait a minute, we have this mortgage registered, but the underlying treaty is now null and void. What's going to happen to my right?" I said, well, in theory, to look at the Russian collateral law, the court can rule this mortgage agreement null, because the underlying agreement does not exist. My employer was terrified. Luckily, we were able to resolve this situation in a quite satisfactory way. But I'm telling you this story to show you how investment business in Russia can come under threat, where you have to register not just the right, but also the agreement that certifies this right. And when the Federal Registry Service accepts the treaty for registration, it does not certify it to certify whether it is in accordance with the civil code or not. It's the risk that is borne by the creditor. I'm very grateful to the Russian lawyers and to the Russian legislators who adopted the amendments that are to come into force in 2 weeks' time that will address these issues. So all the mortgage agreements that will be concluded after July the 1st will need no separate registration. And this means that Russia is transitioning to a normal agreement registration procedure as it exists in other continental law countries, such as Germany. You know that the Russian civil code is very close to the German civil code. Do I have a couple of minutes more so I can continue? Good. Comparing the Russian model of collateral with the German one, I want to say this. The same law that amended the civil code concerning collateral made it possible to use as collateral part or all of the debtor's property. This is a very useful novel, I say. For instance, when we want to exercise the collateral in court, the judge looks at the collateral agreement and asks, now what is the object of collateral? I remember there was a case that made us all laugh when the collateral was a herd of cattle. And this was used as collateral for stock in trade. But cows, as you know, they have the quality of becoming amortized. But certainly cows are a fixed asset for somebody who is in that sort of business. So the statement of collateral gave a description of the herd of cattle numbering so many. But the court said, wait a minute, gentlemen, you can't do it like that, because you need to identify each component of the collateral. You were supposed to individually list each cow, number it, give its name and other descriptors, and so on. You can call it ironic, but for such a deal to be concluded, the creditor and the debtor had to make sure that the court can understand what they mean. A herd of cattle is the cattle that belongs to a particular farm and can be found in a particular meadow. But the court found it not so and needed this personalized description. I would say German banks have an easier life than Russian banks on this count. In Germany, they have this interesting provision. When the client opens, or a corporate client, I mean, opens an account with a bank, and I'm not talking about depositors, they have a deposit protection scheme. I'm talking about a corporate client. First they fill a form, a one-page form, with reference to general business conditions. The general business conditions is a 10-page document in small print, which contains some very interesting provisions. So one of them is this. General right of collateral. The bank writes about it like this. On any liabilities that can arise before the bank only can arise potentially. So with regard to any liability that the client can have arise before the bank and that is not fulfilled, gives the right for give a right to confiscate any property of the clients that is kept with the bank, be it a deposit or securities or gold on deposit or warrants or whatever. I know that it works in practice. It can be exercised. For the bank, it is a holy cow. They would never go back on that. They would never strike away this general right to collateral. It's very important for them. But a while ago, I came up against this situation. One Ukrainian bank was in liquidation, and it had some money in Frankfurt in the account. So this general right of collateral arose under German law, and of course the bank didn't want this money to be returned to the liquidation amount. So my shareholder can use this money to close some of the obligations. That's a business-friendly concept that I think the Russian legislation should adopt. Thank you, Alexander. That was an interesting view from the other side of the divide. Certainly, you're in the business of selling confidence and protection and calculating the risks per unit of protectedness. And now I will turn to Ruslan Ibrahimov for a continuation of this subject. I think I felt the context of this roundtable in the description that we have for this roundtable. Liberalization and dangers thereof, or risks thereof. Any liberalization has a flip side. The legal community is concerned about protection of their assets in relation to liberalization. Entrepreneurs are prepared to pay more to protect themselves against racket. Sounds like it's a dangerous world. I am asking myself, looking out of this window, the Hermitage Museum across the square, is it protected enough? Well, if not the Hermitage, but think about some other Russian museums that do come under attack. Think of Arkhangelskaya. Well, anyway. I'll really talk about two subjects, real estate and rights to securities. With real estate, it's both easier and it's more complex at the same time. We don't register real estate in the usual sense of the word. We mostly register the rights to our line and cable facilities. No liberalization is available there. Maybe in the future we'll see some. But here we're quite confident. We once calculated how long it takes before we can get a piece of property registered. It came to 1 year. And we have to get 32 certifications. Pretty hard for a protection racketeer to take us up on that. Not that they would want to. So we don't feel any important changes in that part of our business. And we don't feel we're under threat here. As to the rights to securities, this makes me think of the roadmap of 2013 known as the lifting of administrative barriers roadmap. We welcome that. The industry needs to develop, and the asset turnover is an important part of it. But development and stability are always in a relationship of controversy with one another. If you want more development, you can't at the same time clamor for more stability. The liberalization norms are quite fresh, and we don't have much experience in their application. So I can't provide to you any statistics about risks that were realized. We can only talk theoretically. Obviously, we want development, but we also want stability with regard to our rights to the assets. So let's look at it from the point of view of legal function, risk management. It's based on risk management. Risk management is what we do every day. Are we prepared to pay more? Yes, we are, but it depends on what we pay for. We would not pay for amendment of legislation. We don't think this is an issue. We would be prepared to pay more for anti-fraud activities. And this is not only true for Russia. We use third parties such as registrars to register the rights to our shares. We are prepared to pay them, but in response, we want them to invest in internal anti-fraud programs. And this, for us, is the way to try and strike a balance between liberalization and rights guarantees. We look at it from the point of view of private law. This is something we might want to invest in. Some market makers, or some of the registrars, already got the message that they are receiving from big issuers, and they are investing in these systems considering the new liberalization. The systems they put in place are quite effective and valid. They will check the identity of the legal entity and compare photographs and signatures, even those of the notaries. They even compare the photographs of visitors with fraudsters' databases, because these are available. Sometimes they call the notary to verify if it's the same person, and so on. Quite detailed activities of anti-fraud actions.
It's quite obvious, having a huge amount of registration activities. Sometimes it's pretty hard to perform fully all these activities. Maybe it's not necessary. So the next step would be privatization. People just looking at the value or the price of the assets, turnover, the market turnovers, organized, not organized. So they look into the previous background or history with respect to these assets, and on the basis of this criteria they are trying to set up a priority system. This system is construed in such a manner that the less risky assets are quite easier to be checked. The more stringent actions are applied to the assets, to these assets. So those who are working in such a manner practically do not face any problems. So once again, for 3 years, this anti-fraud system hasn't produced any problems for such or other people working on the basis of the system. Of course, amendments would produce further problems, further challenges, but we are convinced that it's up to us to be respondent to the changes. No matter how many antivirus programs you purchased, you still will face a lot of viruses coming into your system. That is why our position is still we stand for the evolution, progress, liberalization, but at the same time we are prepared to pay just to make sure that we are secure. Thank you very much for sticking to time rules. I understand that your industry consists of 3, now it's 4 persons. So, thank you very much. Let's move on. Alevtina, what kind of risks are you prepared to pay for, and are you ready to pay extra money in order to get more secure or to be more secured? Or you just feel fine? Colleagues, I just venture to get down a bit into the theory. Now we're talking about the status of the subjects of the civil law in the commercial turnover. What does it mean? I mean the subject, and what is the status in terms of turnover? And I have a subtopic which means the access of the subject to the commercial turnover. Is it easy? Is it not? I would start by discussing the first issue. Now, in fact, we discussing the issue related to the sort of mitigation of control measures, and maybe accompanied by the reduction of costs, even if it is unpredictable. And the key aspect is the predictability of the civil turnover. And let me remind you, last Thursday on a conference, Professor Makovsky, debating about the changes in the legislation, civil legislation, he said that it's quite clear that legislators are understood in their striving to change the disposition measures, but we're trying to achieve this not by the reducing or specifying the norms of the civil law. We are trying to predict a huge number of scenarios or options in the civil law, and as a result we see the problem of over-regulation of this civil law. So this is a problem, and we try to describe this issue in the civil law and civil transaction. We try to take into account all possible scenarios, but it's quite tantamount work, so the work is getting chaotic. So I'm just against the over-regulation of these civil transactions. The other case is it possible today to get rid of this over-regulation? In my opinion, we should be very careful in addressing this issue. We're changing a lot now in our civil legislation and in the legislation in general. We're also trying to rebuild the court system, which is another aspect of the transformation. In the beginning of this panel, it was mentioned that maybe it's due to the lack of the covenant and protection measures, which can lead to the depreciation of these civil measures. But in my opinion, the over-regulation is not a legal deficit. It's just it means that we're trying to reduce overall regulation in order to ensure the proper regulation, but it doesn't mean that we should get off away from the predictability. And predictability means that we would have more possibilities to protect our own rights. Maybe it would be done by registers, as Ruslan said, or maybe notaries. We have a lot of them. But now everything gets down to the definition which is appearing in our legislation is the good faith. So these are the basic notions. Good faith, which is correlated with the personal responsibility, and we understand very well the personal responsibility of the individual participants, the inevitability of this responsibility. No options should not be envisaged. So just to avoid some corruption elements, so we need to increase transparency in terms of the protection in court of your rights. So when all these factors are combined, we can say that the burden of regulation should be diminished, and as a fact, disposition elements should grow in order to ensure the possibility of the subject to go to court to protect its own rights. Then in terms of access to all these things into the civil turnover, what would be the form? Besides this, we have the definition of associated things which are applicable to the turnover of these things in the Russian market, like tarification, certification, and others. When we talk about this in the context of the WTO or GATT, we mean that all this is non-trade barriers. So non-trade barriers in order to ensure access to the market. And by the rules of these organizations, we are committed to reduce these non-tariff barriers. But from the point of view as participants in this turnover, this is the thing that doesn't allow us to take full stock, full toll of all these elements. Maybe I would be rough. Now we are talking about the creeping expropriation, when there are no facts visible, but you see that the price of using the object is equal to zero, especially in the telecom sector, in other industry, foreign, domestic. So in combination, they can change the regime of turnover of these things, and they reduce the output from the use of these things. So we need to understand that not only the form of these things, but the turnover and these non-tariff barriers like certification and so on are very important here. So we should be sensible. We shouldn't go in circle, so we need to ensure the transparent system of access to the market. So this is what we are concerned about as the participants in this turnover. And just as a general comment, what we need to discuss to our bosses in headquarters is the most complex thing is that we are called as a paper-based country. So a lot of bureaucracy, and sometimes these processes could be quite understandable, but they would require a lot of paperwork, a lot of signatures, and a contract consisting of 100 pages would require 100 signatures on each page, and this is quite a complex thing to explain to our foreign colleagues. Why do they need to sign each page? That is why we need to simplify the system, maybe to make it electronic, maybe purchasing antiviruses or not, but nevertheless we should go forward along with the international community. So these are my observations. I hope they are quite relevant. Thank you very much. I think that these 100 signatures require quite a powerful hand of the superiors. They need to have a strong hand. They need to have a good pen and good endurance, just signing the pages for the entire day. So these are the procedures I'm going through, including the banks, which require a lot of paperwork. And we lease facilities where we store this documentation. So we create jobs, additional jobs. So there are mans who prefer vinyl discs. And they explain that there is a sort of pleasure in terms of just get rid of the dust on the vinyl planes. You should put the table. You should put this equipment. So it's the same is true for the signing 100 pages each day. This is maybe it's a pleasure for these guys sitting the whole day and signing these enormous, endless pages. Maybe it's good. Because because you feel that there is no need to think about anything. You just put in your signatures on the pages and that's it. So just a manual work. First you stop thinking, then you start feeling quite confident and quite convenient signing the pages. So the most interesting thing that I would like to stress from your presentation is the fact that we face the dilemma of the determination of the cost mechanism and post factum mechanism. It's not a secret that our countries are based on a quite light administrative models. So these are the countries where Anglo-Saxon countries, where the countries which have light procedures like Singapore, but they have quite enormous and difficult procedures in terms of litigation, so court considerations. And this procedure is 5 times high in Anglo-Saxon countries because they invest a lot in the preventive measures. And for example, the traffic regulation could be done in 2 ways. You put security belts, airbags, child protection chair, frontal protections in the car, just reduce the speed, put speed radars. Or there is another way. Please drive no matter how you want, but if the accident takes place, that it's your responsibility and you go to jail. So this post-factum responsibility is quite an efficient way, and way we debated about the civil code, and we debated the whole things related to the civil responsibility. In the United States they have quite simple corporate procedures, less detailed as we do. And if you find out in the situation of Mendrov or Redov or other guys, you just start calculating the zeros in your prison sentence. So I believe that to a great extent this is the relationship between when we ask the people to pay before or after if after the fire started, then the most happy guys are those who paid for the insurance, because and other people going to vacation abroad and paid for the insurance, but they are not happy because their insurance didn't work. But in terms of fire, they can get this insurance because the fire actually took place. So I would suggest that our speaker from the development of the popular music, the recent intervention is the most forgettable. So, in place of developer, I pay for everything because I understand what garbage you are trying to get rid of in terms of land plots and other real estates. So practically you said everything what I wanted to say. So I tried to save the time.
So, not to repeat what you said, and to keep the situation interesting, I will talk about something else, offer you a different angle on this issue. You can believe me or not, it sounds like a joke, but it's something that happened to me. I once had to provide legal documentation for a large land plot in Belgium. How did you find a large plot in Belgium? Well, we did. Anyway, it was a logistics park that was to be built there. And the process for us as investors stalled because of something, and you will hardly believe me what caused the problem. We had to provide 4 sets of documents on different color paper, each on a different color paper. I had thought that humans have won over bureaucrats in this struggle of civilization, but at that point I knew that we did not. So when today we hear about liberalization of such procedures, I'm gaining some of my trust in humanity back. It has to be reasonable. To me, reasonable means there must be some grounds before it. It must indeed provide some protection for all the parties involved. All the parties that are involved in this, whatever it is, registering a land plot or a car or whatever. And then it must be economically viable. You see, we're usually involved in construction, in land development. There's lots of regulation in this sphere. And we might say that in our area, we are back in the 1970s or 1960s as far as regulation goes. A lot of the regulations are actually in place since then. Well, the way we work is we find a land plot. We expect to build some apartments there and then sell them to people and get our money back. Trying to calculate when we can start getting some sort of returns depends a lot about our estimations of the time we get our permits. If we are very much off the mark on that, this affects our profits directly. Now, liberalization, in my view, must not be confined to the simplification of procedures. Liberalization should also involve a unification of procedures, and it also requires an education of the bureaucrats who operate the system. Bureaucrats from the government side and also the operatives from the business side. I was in the tax office about a week ago. Some need arose to get signatures for some documentation, and I had to get 2 signatures from 2 different windows. Now the 2 people behind those windows doing the same thing on a different set of papers were acting apparently by different rules. So my point is unify, simplify and educate the people who are responsible for doing that about this unification and simplification. And as I said, this requirement must affect not just the government side, but also the business side of the deals. I don't have much experience of protection rackets, but I do have some, and I know what racketeers look to. The first thing they want to discover is some loopholes in the documentation, something that was overlooked or considered too minor to be done well in the first place. When I first came to work in the development business, or came to work for the development businesses, and I was sitting in the first meeting, I was shocked to hear the developers being asked whether or not they had a building permit in place, and the response to that was, well, we're working on it. And this could mean anything. And it meant that the person who asked the question didn't really know what the procedure was. What I actually discovered there was that an incomplete and faulty set of documents was submitted for registration, and of course it was returned. And then the person who brought in this faulty set of documents started complaining about bureaucracy. No amount of simplification can help this sort of negligence and lack of educatedness. Thank you. Thank you very much for your opinion. At least now we have something to take back. This story about 4 sets of documents on different colored paper will be memorable. It sounds promising. Mr. Fomichov might consider painting the different desks in his universal public services centers different colors for that or something. Well, anyway, colleagues, I want to open the floor. How prepared would you be in your line of business to pay more for protection or not? Well, I just wanted to respond to what was said about the rankings and how they do more harm than good. It so happens that in my ministry, part of my job is improving Russia's position in the rankings. And it was gratifying to hear our Italian colleagues say that it doesn't matter very much. Certainly all these rankings don't affect anything useful in the sphere of doing business. If a certain procedure takes 5 days when it used to take 7 days, it makes no major difference. Well, it can be important for a shell company, for an overnight company. This is close to its life cycle length. No, it does not. But if this reduction in time from 7 days to 5 days would make Russia rise a little bit in the rankings, why not do it? These rankings, say what you will about them. For investors that are considering coming into Russia, this ranking can be a guideline, if not a decisive factor. An investor who is trying to make a choice out of 20 possible options will be to look at these rankings. Such an investor would not go into the last 50 countries in the rankings, and he's not interested in the top 10 because he already knows all about them. He's considering those countries listed in the middle. If you are too low in that ranking, you may never get some of the investment that you might. And something about I want to respond to what Chairman said about procedures that happened before or after the fact. We are, in fact, removing the procedures that take place of the fact.
I was not saying that to gain in the rank is a bad thing. It's very nice indeed. But I was saying that the data are, how to say, mistaken, misunderstood, and so on. Let's see Italy, registering property. Check on the doing business page. They say, first step is notary obtains necessary permit. Less, and in the timing is marked less than a day, and simultaneous, so less than a day, which is true, and simultaneous with procedure 2 and 3. Let's see procedure 2. Less than a day, and it's true again, this is the use of website to check register, cadastral register, less than a day, and simultaneous with procedure 1 and 3. Procedure 3, 11 days, I don't know why 11, it could be 3, 4, 5, or 25 if we can't find the documents, but it's 11, simultaneous with procedure 1 and 2. Fourth step, 2 days, and so we have summing up 16. So how can you get 16 if you say less than 1, 11 simultaneous, and 2? So 11 if simultaneous as a sentence is 11, and 2 are 13. Why the summing up is 16? No, this was the I say that this is probably a joke, but so please, it's
creative accounting.
just an invitation. Check it yourself, and you will find that this famous and mathematical or scientific database that the World Bank has the pleasure to give us every year is not so precise, so scientific, and so mathematical as it looks like, or as it would like to look. It's just an element of fact, not of the value or the consideration that we will have about the duration of these proceedings. I'm in the matter. I can say that 11 days for signing the document or collecting all the documents for an alternator, it's too long. But this is another thing. But just check that. 0, 0, 11, 2 makes a sum of 16, sorry.
Спасибо.
Thank you. Do we have any more comments or questions? Or maybe you have something to say about the doing business ranking? I would propose as something for you to take away from this meeting is try to assess where you stand in the doing business ranking. each one of us. Well, I think it was an interesting discussion altogether. If there are no questions from the floor, it means that the meeting was a failure, but that makes it a shorter meeting, which is a happy sign, don't you think? Well, I happen to be the peacemaker in this group. So let me conclude by making complete peace between the two ministries represented here that seem to be warring. I can say that Federal Law 115 has set us at peace. The law on reducing terrorist threats. It says that when opening accounts with registrars, we need to require more documents to be produced than the list that we had been trying to reduce. And notary proxy deeds must now be produced not just in copy but in the original, and so on. So I suppose we can say that we have reconciled the two ministries here, and it's a good thing that you didn't fight. All right, so we have something to hope for, even for Belgian registrars that want to see 4 different colors of paper for their documents. Thank you. This concludes the meeting.